Next page, Separation of Powers in the Three Branches of Government 3.1 Introduction. The study of government branches is best done through the lens of the separation of powers doctrine. The South African version of separation of powers is still being developed by the judiciary through constitutional interpretation. Previous discussions, Chapter 2, covered Global Constitutional Systems Approaches to Separation of Powers. Initial development of the doctrine in South Africa. The next three chapters focus on legislature, executive, and judiciary, as established by the South African Constitution, 1996. Chapter 9 Institutions and the National Prosecuting Authority, NPA. The checks and balances system between these branches. South African context and traditional leadership. The study of separation of powers must be contextualized within South Africa's governance landscape, including the resurgence of traditional leadership post-apartheid. The constitutional role of traditional leaders and governance structures. A key constitutional question: where do traditional governance structures fit within the separation of powers doctrine? Some scholars argue, the resurgence of customary institutions is expected, given their historical entrenchment in South Africa. Traditional authorities have long engaged with other forms of governance in Southern Africa. Supporters see traditional governance as providing continuity, especially in rural areas with limited democratic state influence. Critics argue, traditional governance undermines democratic consolidation. It is often undemocratic, patriarchal, and potentially oppressive. Legal framework regulating traditional leadership, National House of Traditional Leaders Act, created by Parliament under Section 212(2)(a) of the Constitution. Traditional and Khoisan Leadership Act further regulates traditional governance. Centers of power in South Africa. South African constitutional law traditionally focuses on Western-style structures but ignores informal governance elements. Two main power centers: 1. Formal institutions, legislature, executive, and judiciary, regulated by the Constitution. 2. Informal governance, traditional leadership structures, influenced by history and social dynamics. Role of political parties in separation of powers. Political parties play a central role in shaping government operations. Power is concentrated in dominant political parties, particularly their leadership. Influence of major parties: African National Congress, ANC, Democratic Alliance, DA, Economic Freedom Fighters, EFF. The internal culture and leadership style of these parties influence the legislature. The executive. Chapter 9 Institutions and Oversight Functions. Chapter 9 Institutions were created to support constitutional democracy, provide oversight over the three branches of government, strengthen democratic governance. Discussion focuses on Public Protector, Auditor General, Electoral Commission, Judicial Service Commission, JSC. Next page. Separation of powers in the three branches of government. 3.2 A new democratic constitutional dispensation within a system of separation of powers. 1993 Interim Constitution and 1996 Constitution established a transition from rule by parliament constitutional supremacy, rule by force democratic principles, equality, and freedom. These changes affected the legislative, executive, and judicial branches. Governance structures at provincial and local levels. The Constitution introduced a more defined separation of powers, although not entirely strict. The following chapters analyze the national sphere of government and its institutions that regulate public power. The three branches of government under the Constitution. 1. Legislature, Parliament, National Assembly, NA, and National Council of Provinces, NCOP, people's representatives with the highest lawmaking authority. 2. Executive. President and cabinet ministers. Ministers lead government portfolios and perform executive functions. 3. Judiciary. Judicial review of government actions. Section 165 of the Constitution, courts exercise judicial authority, are independent, and subject only to the law and the Constitution. Constitutional structure and separation of powers. The Constitution entrenches separation of powers through specific chapters. Chapter 4, Legislative Authority. Chapter 5, Executive Authority. Chapter 8, Judicial Authority. Separation of powers is not explicitly mentioned but is firmly entrenched in the constitutional framework. Case law confirming separation of powers. Glenister v. President of the Republic of South Africa and others, Glenister I, Long CJ stated separation of powers is axiomatic to the constitutional design. Doctors for Life International v. Speaker of the National Assembly and others, and Kobo J. highlighted that constitutional structure reflects separation of powers. Judiciary's unique role. Courts check whether legislature and executive comply with the Constitution. This places the judiciary in a position of final constitutional authority. Constitutional supremacy means all branches must act within constitutional limits as interpreted by the courts. Next page. Judicial oversight in the limits of judicial authority. Role of the courts in enforcing constitutional supremacy. Doctors for Life case. The Constitution is supreme, meaning all obligations imposed by it must be fulfilled. Courts are required to ensure that all branches of government act within the law. Constitutional Court is the ultimate guardian of the Constitution and its values. Section 167 4e entrusts the Constitutional Court with ensuring Parliament fulfills its constitutional obligations. The Supremacy Clause reinforces this duty, making it clear that courts cannot be deprived of jurisdiction to enforce the Constitution. Judicial restraint in the limits of judicial authority. Courts must enforce constitutional compliance while recognizing the limits of judicial power. Avoid interfering in executive and legislative functions unless mandated by the Constitution. Only intervene when another branch fails to meet its constitutional obligations. Case law on judicial intervention in government affairs. Glenister Rye. The separation of powers requires courts to ensure government acts within constitutional limits. However, courts must still respect the limits of their authority. Doctors for Life test for judicial intervention. Courts may intervene in the legislative process only if no effective remedy will be available after the process is complete. The unlawful conduct will have already achieved its purpose. The harm caused will be material and irreversible. Next page. A dialogic model of the separation of powers doctrine. Purpose of the separation of powers. Enables governance, lawmaking, and law enforcement to be performed by institutions best equipped for each function. Prevents overconcentration of power in a single body or individual. Post-liberal, dialogic model. Traditional liberal model, strictly demarcated spheres, which may hinder transformation. Post-liberal model. Ensures accountability, responsiveness, and openness. Focuses on whether branches can mutually define their boundaries rather than strict non-interference. Encourages a constitutional dialogue between branches to test power limits. Supports transformative jurisprudence, aligning with South Africa's transformative constitution. Certification of the 1996 Constitution. No universal model of separation of powers. The principle of separation of powers recognizes functional independence of branches, includes checks and balances to prevent power usurpation. Partial separation is inevitable, as branches will intrude on each other's domains when necessary. Judicial role in separation of powers. Courts must regulate and safeguard the separation of powers, intervene when necessary to prevent constitutional violations, balance judicial limits to avoid excessive intrusion into executive and legislative affairs. Counter majoritarian concern. Courts may be accused of overreaching when intervening in government matters. Legislative and executive intrusion into the judiciary. Legislature's role. Can impose limits on sentencing powers, but only to a constitutional extent. Executive's role. Engagement with the judiciary must not compromise judicial independence. Private discussions or mechanisms to align government branches may be unconstitutional if they undermine judicial impartiality. Next page. Summary of separation of powers. 3 branches of government. Legislature, lawmaking authority. Executive, policy implementation. Judiciary, constitutional interpretation and enforcement. Separation of powers doctrine. Essential for understanding how government functions. Defines relationships and limits of each branch's power. Judiciary's unique role. Requires high independence from the other branches. Ensures compliance with the Constitution. Challenges to the model. Traditional leadership and Chapter 9 institutions do not fit neatly within the separation of powers framework. Next page. Separation of powers in the national legislature. 4.1 Introduction. Separation of powers distributes public power among the legislature, executive, and judiciary to prevent abuse and ensure accountability. The Constitution does not explicitly mention separation of powers but divides national government into 3 branches. Parliament's constitutional responsibilities, as per Economic Freedom Fighters v. Speaker of the National Assembly. represents the aspirations of all South Africans, especially the vulnerable. Holds the executive accountable for promises made to the people. Maintains oversight of state resources and fiscal discipline. Passes, amends, or rejects legislation within its authority. 4.2 The structure and composition of Parliament. 4.2.1 The structure of Parliament. Bicameral system. National Assembly, NA, represents the people and is elected through proportional representation. National Council of Provinces, NCOP, represents provincial interests at the national level. 4.2.2 The role of political parties. Political parties play a central role in Parliament, particularly under the proportional representation system. Party discipline affects parliamentary proceedings, voting, and accountability. 4.3 General rules regarding the operation of Parliament. 4.3.1 Introduction. Parliament operates under constitutional principles of transparency, accountability, and public participation. 4.3.2 Openness and transparency in Parliament. Public access to parliamentary proceedings ensures accountability. Sessions are broadcast and open to the public unless confidentiality is required. 4.3.3 Powers and privileges of members of Parliament. MPs had parliamentary privileges to enable them to perform their duties without fear of external influence. Freedom of speech in Parliament is protected under the Constitution. 4.3.4 Public involvement in legislative processes. The National Assembly (NCOP) must facilitate public participation in legislative processes. 4.4 The National Assembly. 4.4.1 Composition of the National Assembly. Consists of members elected through proportional representation. 4.4.2 Party proportional representation electoral system. Ensures fair representation based on party vote share. 4.4.3 New Nation Movement NPCP President of the Republic of South Africa. This case challenged the electoral system's exclusion of independent candidates. The Constitutional Court ruled that the electoral system must allow independent candidates to contest elections. 4.4.4 The right to vote and the Electoral Commission. Electoral Commission ensures free and fair elections and protects the right to vote. 4.4.5 Eligibility for election to the National Assembly. Requirements include South African citizenship and no criminal record for serious offenses. 4.4.6 Duration, sittings, and dissolution of the National Assembly. 5-year term, subject to early dissolution under specific circumstances. 4.4.7 Powers and functioning of the National Assembly. The National Assembly passes legislation, holds the executive accountable, oversees state institutions. 4.5 The National Council of Provinces, NCOP. 4.5.1 Composition and functioning of the NCOP. Represents provinces at the national level. Each province has equal representation, regardless of population size. 4.5.2 Procedures, internal arrangements, and committees of the NCOP. The NCOP operates through committees and voting on provincial matters. 4.6 Functions of Parliament. 4.6.1 Introduction. Parliament performs legislative, oversight, and representative functions. 4.6.2 National Forum for public consideration of issues. Provides a platform for debating national issues. 4.6.3 Holding the executive accountable to Parliament. Ensures the executive fulfills its constitutional obligations. 4.6.4 Maintaining oversight of the executive and state organs. Parliament monitors government spending and decision-making. 4.6.5 Passing legislation. Parliament has the authority to make and amend laws. 4.6.6 Delegation of legislative powers. Parliament may delegate specific powers to the executive or provincial legislatures. Summary. Parliament is the legislative authority in South Africa, responsible for lawmaking, oversight, and public representation. The National Assembly and NCOP work together to ensure legislation reflects national and provincial interests. Public involvement and transparency are key principles governing parliamentary processes. Court rulings, for example, New Nation Movement NPCP President of South Africa, influence the evolving role of Parliament. Next page. 4.2 The structure and composition of Parliament. 4.2.1 The structure of Parliament. Bicameral legislature. National Assembly, NA, represents the people. National Council of Provinces, NCOP, represents the provinces. Purpose of bicameralism. ensures representation of different interests, acts as a check on each house's power, promotes thorough consideration of legislative matters, election/appointment process. Non-members, elected through proportional representation in national elections, NCOP delegates, indirectly elected via provincial legislatures. Dominance of the National Assembly. The NA is the more powerful house because it elects and dismisses the president, provides the majority of the executive members, holds the executive accountable and oversees national executive authority, appoints key officials, including Chapter 9 institution commissioners. The role of the National Council of Provinces. The NCOP has a weaker role in holding the executive accountable, no authority over executive appointments or dismissals, represents provinces, ensuring their interests are considered in national legislation. Location and sittings of Parliament. Seat of Parliament, Cape Town. Parliament may sit elsewhere for public interest, security, or convenience, as per rules of the NCOP. 4.2.2 The role of political parties. Parliamentary democracy is mediated through political parties. No person can become an MP unless they belong to a political party. The majority party in the NA forms the government. Party government system. Political parties influence the composition of government, policies, and actions of elected representatives. Strong party discipline exists due to conventions inherited from British constitutional law. Certification of the Constitution of the Republic of South Africa, 1996, first certification, judgment. Confirmed political parties' role in South Africa's constitutional system. Electorate votes for parties, which must be accountable to the voters. Limited regulation of political parties. The Constitution and national legislation provide little guidance on internal party operations. Unclear extent of control party leaders have over members in Parliament. Judgment, United Democratic Movement v. Speaker of the National Assembly and others. Issue, whether the Speaker could allow a secret ballot in a presidential impeachment vote. Court ruling. The Speaker has the power to permit a secret ballot. MPs may face party consequences for voting against their party but retain freedom of conscience. MPs' primary duty is to the Constitution and the people, not their political party. Next page. The rights of citizens as members of political parties. Legal framework and internal party democracy. The Constitution does not clearly define the relationship between political parties and their leaders. Elected representatives of political parties serving in Parliament. Case, Ramaphosa and others v. Magashule and others. The Constitutional Court affirmed the link between internal party democracy and the right of citizens to participate in elections. Yacob-J's ruling. Political parties must act lawfully and follow their own constitutions. Citizens have a right to demand compliance with party rules. South Africa's electoral system. Based on proportional representation, citizens vote for political parties, not individual candidates. Political parties nominate candidates on regional and national lists. Parties are essential for citizens to exercise their voting rights. Internal elections and party constitutions. Members have the right to participate in internal elections free from interference. Political parties must not adopt constitutions that violate the Bill of Rights. Section 19. A party's constitution can be declared invalid if it restricts members' rights. Party influence over members of Parliament. Contradiction between UDM judgment and political reality. United Democratic Movement v. Speaker of the National Assembly and others emphasize that MPs must prioritize serving the people over party loyalty. In practice, political parties and their leaders hold significant power over MPs. Reasons for strong party control over MPs. 1. Parliamentary system, British influence. Government needs majority party support to survive. MPs must support party decisions, even if they disagree. If the ruling party loses votes in Parliament, it can collapse the government. 2. Westminster system and party discipline. Strict party discipline is a key feature. MPs cannot freely oppose party leaders in legislative or executive decisions. This system was followed in pre-1994 South Africa and continues today. 3. Internal culture of South African political parties. Party loyalty is highly valued and rewarded. Some parties practice democratic centralism. Internal debate is allowed before a decision is made. Once a decision is final, all members must support it. Criticism or deviation is not tolerated. 4. Electoral system and party control over MPs. MPs depend on their party's support to get elected. Party leaders can remove MPs from Parliament. MPs must follow party instructions on voting, even if they disagree with party policies. If a party supports a bill, MPs must vote for it, even if they oppose it. Practical impact on parliamentary functioning. Party decisions bind MPs. If a party decides on a specific stance, MPs must follow it. Only when a party has not taken a public stance is there some flexibility. MPs' constitutional duties, for example, passing laws, holding the executive accountable, may be compromised due to party loyalty pressures. The relationship between MPs, political parties, and the executive is crucial for understanding how Parliament operates in practice. Next page. Difficulties faced by MPs in balancing constitutional obligations and party loyalty. Conflicting obligations. The Constitutional Court has ruled that MPs must uphold constitutional values above party loyalty. However, in practice, defying the party can lead to severe consequences, including disciplinary action, expulsion from the party, loss of parliamentary seat. This pressure applies to MPs across all parties. Party discipline and consequences for dissent. Case study, ANC MPs. ANC Constitution requires all elected officials to be members of the appropriate caucus, follow caucus rules and decisions. Failure to comply can lead to disciplinary action, including suspension or expulsion. Example, Ben Turok, 2011, refused to vote for the Protection of State Information Bill, walked out of the National Assembly before the vote, defended his decision in an SAFM radio interview, citing ethical concerns, received a disciplinary charge sheet accusing him of being a counter-revolutionary. The ANC later dropped the charges, but under its rules, it could have proceeded with disciplinary action. Example, Dr. Makosi Kaza publicly criticized former President Jacob Zuma, faced threats of disciplinary action, resigned from the ANC to avoid potential expulsion. Challenges for MPs. MPs are expected to hold the executive accountable, pass constitutionally valid laws, exercise independent judgment. However, they are simultaneously required to follow party decisions, support party leadership, vote according to party instructions, even if they disagree. Conclusion. The practical reality of parliamentary politics makes it difficult for MPs to fully exercise their constitutional duties. The threat of party discipline forces many MPs to prioritize party loyalty over independent decision-making. Next page. 4.3 General Rules regarding the operation of Parliament. 4.3.1 Introduction. The National Assembly, NA, and the National Council of Provinces, NCOP, had the power to control their internal arrangements, proceedings, and procedures, make joint rules and orders for their joint business, establish rules separately for their own operations. The Constitution requires rules for composition, powers, and functioning of committees. Rules conflicting with the Constitution may be declared invalid by a court. Failure to make required rules can result in a constitutional breach, as ruled by the Constitutional Court. Parliamentary powers. Both houses and their committees have broad powers, including the ability to summon any person, including the President and Cabinet Ministers, to give evidence under oath, produce documents, require reports from any person or institution, compel compliance with summons or document production, receive petitions, representations, or submissions from interested parties. Witnesses who refuse to appear voluntarily may be summoned and compelled to testify. The rules of the National Assembly require that a committee must justify the necessity of summoning a witness. The Speaker's approval is required before issuing a summons. Limitations on parliamentary powers. 1. Openness and transparency. Parliament must act openly and transparently and cannot adopt rules that undermine openness. 2. Parliamentary privileges. MPs and cabinet members appearing before Parliament enjoy certain privileges that cannot be restricted. 3. Public involvement. Parliament must facilitate public involvement in legislative and other processes. Underscore. 4.3.2 Openness and transparency in Parliament. South Africa's democracy is based on open governance, allowing citizens to participate. The Constitution mandates that NA-NCOP must conduct business in an open manner. Sittings and committee meetings must be held in public. Public access and the right to vote. Citizens can only exercise their right to vote effectively if they know what their representatives do in Parliament. As most people cannot attend Parliament, they rely on media coverage. Limiting journalistic access restricts public rights. Doctors for Life International v. Speaker of the National Assembly. Key ruling. Public participation is essential for representative democracy. Open proceedings help citizens identify with government institutions. Public access strengthens the legitimacy of legislation. Transparency prevents secret lobbying and undue influence. Regulating public and media access. Parliament may take reasonable measures to regulate media access, security screenings, restrictions on entry and removal of disruptive individuals. Primedia Broadcasting v. Speaker of the National Assembly, 2015, the Supreme Court of Appeal, SCA, ruled that restrictions on public access must be proportionate to the objective, justifiable in a democratic society. Case facts. During the 2015 State of the Nation Address, SONA, the State Security Agency used signal jamming to disrupt telecommunication access, restricted parliamentary broadcast feeds to avoid showing disruptions. Court ruling. The signal jamming was unconstitutional. Censorship of broadcast feeds was unlawful. Exclusion of the public from parliamentary proceedings. The NA-NCOP cannot exclude the public or media from proceedings except in exceptional cases. Constitutional standard. Exclusion must be reasonable and justifiable in an open and democratic society. Rule 57. One of the NA rules. The Speaker controls visitor access to Parliament. Access regulation must comply with Section 59 of the Constitution. Constitutional Court and Doctors for Life. Openness provisions are procedural requirements like quorum and voting rules. Failure to comply could affect the validity of legislation. Next page. 4.3.3 The powers and privileges of members of Parliament. Limits on Parliament's power. Parliament's power to set its procedures is constrained by the Constitution, particularly in terms of openness, accountability, and transparency. Parliamentary privileges are conferred on cabinet ministers, deputy ministers, and members of the NA-NCOP, which include freedom of speech and immunity from civil/criminal proceedings, arrest, imprisonment, or damages related to actions within Parliament or committees. Purpose of parliamentary privilege. Ensures MPs can speak freely without fear of legal repercussions, allowing them to carry out their work and expose wrongdoing effectively. Parliament's authority is reinforced by this privilege, enabling it to hold the executive accountable and act as a forum for citizen concerns. Parliamentary privilege does not extend to personal matters, as shown in Dakoko v. Makatlaw, where defamatory remarks not related to the municipality's business were not protected. Historical context. Parliamentary privilege originated in the British context and was gradually recognized in law. The South African Constitution similarly protects the freedom of speech of members of Parliament and its committees under specific conditions. Legal precedent. In Speaker of the National Assembly v. de Lille MP and another, Patricia de Lille, an opposition MP, was suspended after making controversial statements about governing party members. The court ruled that Parliament's decision to suspend her for exercising free speech violated her constitutional rights, including freedom of expression, Section 16, administrative justice, Section 33, and access to courts, Section 34. The Supreme Court of Appeal upheld the High Court's decision, emphasizing that Parliament's actions must align with the Constitution, particularly the freedom of speech guaranteed by Section 58(1). Impact of ruling. The case established that the exercise of parliamentary privilege is subject to judicial review to ensure it conforms to constitutional rights. Suspension of MPs for free speech in Parliament was deemed unconstitutional, setting a precedent for future cases. Rules of the National Assembly were amended, granting the Speaker or Deputy Speaker authority to suspend members for between 5 to 20 parliamentary working days. Next page. Democratic Alliance v. Speaker of the National Assembly and others. Case background. During President Zuma's 2015 State of the Nation address, members of the Economic Freedom Fighters, EFF, interrupted him, asking about the repayment of public funds spent on upgrades to his Nkandla residence. The Speaker instructed the EFF members to leave, but they refused, leading to their forcible removal by police under Section 11 of the Powers, Privileges and Immunities of Parliament and Provincial Legislatures Act, PPI Act. Legal challenge. The Democratic Alliance, DA, applied to the Western Cape High Court, seeking to declare Section 11 of the PPI Act unconstitutional, arguing that it infringed the parliamentary privilege of freedom of speech guaranteed by Section 58(1)(a) of the Constitution. The High Court ruled in favor of the DA, declaring Section 11 unconstitutional, and the case was referred to the Constitutional Court for confirmation. Constitutional Court's decision. Purpose of parliamentary privilege. The court emphasized that freedom of speech in Parliament promotes a pluralistic and deliberative body, allowing MPs to participate fully without fear of arrest, imprisonment, or legal action. Limitations of parliamentary privilege. The privilege is not absolute and can be limited by the rules and orders of the National Assembly. MPs are not allowed to disrupt proceedings or impair the ability to conduct business. Interpretation of disturbance. Section 11 of the PPI Act was found to apply to any person causing a disturbance, which was interpreted to include MPs. However, the court held that disturbance should not be interpreted too broadly, as doing so could infringe the privilege of free speech. A disturbance must prevent Parliament from conducting its business for a significant period. Chilling effect of Section 11. The court concluded that Section 11, when read with Sections 7 and 27 of the PPI Act, which criminalize participation in disturbances, had a chilling effect on MPs' freedom of speech. Constitutional concerns. Internal versus external limitation. Section 58(1) of the Constitution states that parliamentary privilege can only be limited by Parliament's internal rules and orders, not by an Act of Parliament. Allowing Parliament's freedom of speech to be limited by external legislation would undermine its autonomy, as it would involve the executive branch in a process that the Constitution reserves for Parliament. Outcome. The Constitutional Court confirmed that Section 11 of the PPI Act was unconstitutional and invalid. The case reinforced that the parliamentary privilege of freedom of speech is fundamental and must be protected from external interference, particularly from executive or legislative actions that do not originate within Parliament. Next page. Parliamentary privilege and robust discussion in Parliament. Core principle. In Democratic Alliance v. Speaker of the National Assembly and others, the Constitutional Court emphasized that the parliamentary privilege of MPs protects not just their speech, but also conduct that might annoy or test the patience of the presiding officer. This highlights the robust nature of parliamentary debates. Robustness in debate. Parliamentary debates often involve heated exchanges, and the court stressed that in such environments, MPs must not be stifled by the presiding officer's rulings. Members should have the freedom to continue their contributions even if they test the limits of tolerance or cause frustration. Limitations on disruptive behavior. While MPs have the freedom to express themselves, the court also held that this freedom of speech is not absolute. It cannot extend to disrupting the proceedings of Parliament in a way that impairs its ability to conduct business. Section 58(1)(a) and Section 71(1)(a) of the Constitution protect MPs' freedom of speech but do not allow license to disrupt Parliament's functionality. Internal control mechanisms. Parliament is empowered by Section 57(1) to maintain internal order and discipline. This includes the power to exclude MPs temporarily who are obstructing proceedings or impairing Parliament's ability to function effectively. The court affirmed that this wide authority allows the Assembly to discipline MPs without undermining the essential function of debate. Striking a balance. The court stressed the need for a balance between protecting the freedom of expression of MPs and ensuring Parliament's ability to function properly. Rules regulating behavior can be imposed when necessary to protect the integrity of the debate, ensuring that disruptive actions do not hinder the freedom of expression of fellow MPs or the overall functioning of Parliament. Conclusion. The privilege of free speech in Parliament is critical for robust discussion, but it must be balanced against the need for order and discipline to allow Parliament to function effectively. Therefore, while MPs should be free to express themselves, there are reasonable limits to prevent behavior that undermines the democratic process. Next page. Public involvement in the legislative process. Constitutional basis for public participation. South Africa's constitution emphasizes both representative and participatory democracy, requiring the National Assembly, NA, and the National Council of Provinces, NCOP, to facilitate public involvement in legislative processes. Public involvement ensures citizens can engage meaningfully in the democratic process, contributing to more informed decision-making and legislation. Participatory democracy. Participatory democracy encourages citizens to be actively involved in decision-making processes, particularly in lawmaking. This participation can occur directly or indirectly, through activities like lobbying, constituency offices, petitions, and public hearings. Importance of public participation. Active public participation is essential for a vibrant democracy, fostering accountability and transparency. It ensures that legislation reflects the needs and interests of the populace, strengthening civic dignity and engagement. The Reconstruction and Development Program highlighted the importance of informed, empowered citizens and called for collaboration between government and civil society. Key mechanisms of public involvement. Lobbying. Civil society groups present arguments to decision makers. Constituency offices. Citizens raise issues with elected representatives who then bring these matters to the legislature. Petitions. Citizens can raise concerns formally without needing a legislator to sponsor the issue. Public hearings, held by standing committees, allowing citizens to make written or oral submissions on issues being considered. Legal framework for public participation. The Constitution requires Parliament to facilitate public involvement under Section 59(1), National Assembly, and Section 72(1), NCOP. Failure to provide reasonable steps for participation can lead to a law being declared invalid. Doctors for Life International v. Speaker of the National Assembly, 2006, reaffirmed the importance of public involvement in the legislative process, particularly in instances where Parliament fails to facilitate this process. Court's view on public participation. The Constitutional Court stressed that representative and participatory elements of democracy are mutually supportive and must not be in tension. Nkobo J. noted the importance of continuous public participation in ensuring legitimacy and effectiveness of legislation. Parliament's discretion to facilitate public participation is not unlimited. The reasonableness of Parliament's actions is determined by factors such as the nature of the legislation, practical feasibility, and public input opportunities. Key factors for assessing reasonableness. Nature and importance of the legislation and its impact on the public. Practical considerations like time, cost, and efficiency of the lawmaking process. Parliament's own assessment of appropriate public involvement, considering urgency and the nature of the legislation. Parliament's duty. Parliament is required to provide meaningful opportunities for public participation and to ensure all citizens can effectively engage in the process, regardless of their socio-economic status. Practical steps must be taken to inform citizens about legislation and how they can participate. International obligations. South Africa's commitment to public participation is consistent with its international obligations under Articles 19 and 25 of the International Covenant on Civil and Political Rights, ICPR. The ICPR guarantees freedom of expression and political rights, including participation in public affairs, reflecting the constitutional right of South African citizens to engage in government. Conclusion. The Doctors for Life case underscores the constitutional obligation for Parliament to facilitate public participation in the lawmaking process, ensuring that South Africa's democracy remains robust, transparent, and inclusive. Next page. The role of voters in the lawmaking process. Jaco Obje's Minority View, Doctors for Life case. Representation by MPs. Jaco Obje argued that MPs represent the people because they are elected by the people. He emphasized that MPs make decisions in the interest of the public, not their own personal interests. Legislative decision-making. The decisions made by Parliament are not just those of the MPs but represent the political will of the people, as expressed through free and fair elections. Mandate from the people. MPs, especially those in the National Assembly and provincial legislatures, act as mandated representatives of the people. This mandate is akin to the process where the president is elected by the people, reinforcing the idea that Parliament's decisions are made by the people through their elected officials. Key consideration. The view suggests that the role of political parties in the democratic process is crucial, and undermining this role could weaken the representative democracy system. Majority view. Nkobo J. Public participation. The majority decision, Nkobo J., focused on the importance of public participation in the legislative process. MPs must ensure that citizens' voices are heard, particularly in the lawmaking process, to strengthen the democratic nature of the system. Dynamic engagement. This view advocates for more active involvement of the public in decision-making, rather than relying solely on MPs to represent the people's will without ongoing consultation. Effectiveness of parliamentary accountability. Potential lack of responsiveness. MPs, particularly those from a majority political party, may become unresponsive to the electorate's views after elections, leading to laws that do not align with public opinion. The larger the majority of a party, the more likely it is that MPs will not feel compelled to consult with voters regularly. Voter accountability. On the other hand, voters have the power to change their political representation at the next election if they are dissatisfied with how MPs have represented them. The right to vote for a different party ensures a system of indirect accountability, where voters can express their preferences through elections every 5 years. Role of political parties. This perspective suggests that political parties are essential to the democratic process. Their influence in Parliament should not be diminished by imposing constant constitutional obligations on MPs to consult voters between elections. Balancing public participation and representative democracy. Democratic accountability. The debate centers on finding the balance between having responsive MPs who actively engage with the electorate and ensuring that political parties retain their essential role in shaping public policy and legislation. Effectiveness of democracy. Both perspectives highlight the need for Parliament to be democratically accountable and responsive to voters, but they differ in their approach to how much direct consultation MPs should have with the electorate during the legislative process. Next. Page 4.4 The National Assembly. 4.4.1 The composition of the National Assembly. Bicameral Parliament. South Africa's parliament consists of two houses, the National Assembly, NA, and the National Council of Provinces, NCOP, Section 42(1) of the Constitution. Number of members. The NA consists of 350 to 400 members, with the exact number determined by an Act of Parliament. Currently, the Electoral Act Schedule 3 sets the number at 400. Electoral system. Members of the NA are elected through a proportional representation system based on universal adult suffrage, a national common voters' roll, regular elections, a multi-party system. This system ensures accountability, responsiveness, and openness. 4.4.2 The Party Proportional Representation Electoral System. System Overview. Before the New Nation Movement judgment, members were elected through a party proportional representation system, where political parties submit a list of candidates, ranking them by preference. Voters vote for a party, not individual candidates. Seats are allocated based on the percentage of votes each party receives. For example, a party receiving 50% of votes would get 200 of the 400 seats, and the first 200 candidates on the party's list would be elected. Internal party decisions. Political parties decide how to rank candidates, either democratically or undemocratically. Party constitutions govern this process but must adhere to Section 19 of the Constitution, ensuring free participation of members. Advantages of party proportional representation. Accurate reflection of voter preferences. The system allocates seats proportionally to the votes, reducing wasted votes. Inclusive representation. Smaller parties, as well as marginalized or previously discriminated groups, like women, are better represented. Prevents gerrymandering. No constituency boundaries are drawn, preventing gerrymandering. Reduces pork barrel politics. Without constituency representation, MPs are less likely to engage in spending to secure local support for projects. Simplicity. The system is simple and easy to administer. Disadvantages. The system may weaken direct connection between MPs and the constituencies they represent, reducing accountability to specific geographic areas. Representation of women in South Africa's parliament. 2019 election, women made up 45% of the NA members, marking the highest representation since 1994, a significant increase from 40% in 2014. Table 4.1 Women in Politics in South Africa. Data showing an increasing trend of women's representation in South Africa's National Assembly. Table 4.2 Representation of political parties in Parliament, 2019, seats allocation, by party. ANC 230 seats, 57.5%, DA, 84 seats, 20.77%, EFF, 44 seats, 10.80%, IFP, 14 seats, 3.38%, other parties, ACDP, 4, UDM, 2, NFP, 2, and several smaller parties. This system supports diverse party representation, providing an accurate reflection of voters' preferences across the country. Next. However, there are also major disadvantages associated with the system. First, a party proportional representation electoral system does not create a strong link between voters and their elected representatives. This has the potential to lead to a lack of responsiveness to the concerns of voters by elected MPs. In this system, the political party as a whole rather than individual MPs has to account to voters at the next election. Individual MPs do not lose their seats because of the anger of voters but because they have lost support within their political party. 141 Second, the party proportional representation electoral system potentially gives much power to the leaders of a party who may be able to determine or influence who appears on electoral lists and where on those lists they are ranked. This means that the leaders of political parties may have disproportionate influence over the way in which individual MPs behave. Third, the system potentially produces a less effective and stable government, especially where one political party is not dominant. This is because a single party may not gain an overall majority in parliament and will then have to form a coalition government with other parties. A coalition government may find it difficult to agree on all aspects of a joint program of action. 142 This disadvantage has manifested itself at the local government level in South Africa. Following the 2016 local government elections, the Democratic Alliance formed either coalition governments, involving a formal agreement on a policy platform between a group of parties, or minority governments, involving no formal agreement on a policy platform, but an agreement to support the minority government on a case-by-case basis, in 3 metropolitan municipalities, namely Tshwane, Johannesburg, and Nelson Mandela Bay. As a result of disagreements among the participating parties, all 3 coalitions collapsed and the Democratic Alliance ceased being the ruling party in Johannesburg and Nelson Mandela Bay. Page. Disadvantages of the party proportional representation electoral system. 1. Weak link between voters and elected representatives. Lack of responsiveness. The system does not create a direct connection between voters and their MPs, making MPs less responsive to voter concerns. Accountability shift. Voters hold the political party accountable at elections, not individual MPs. MPs lose seats based on party support rather than voter dissatisfaction. 2. Concentration of power in party leaders. Influence of party leaders. Party leaders can significantly influence or control the ranking of candidates on electoral lists, which may give them disproportionate power over MPs' behavior and priorities. 3. Potential for a less effective and stable government. Coalition government challenges. In the absence of a dominant political party, coalition governments become necessary, which can create instability. Disagreements between parties can undermine government effectiveness. Local government example. After the 2016 local government elections, the Democratic Alliance, DA, formed coalition or minority governments in municipalities like Tshwane, Johannesburg, and Nelson Mandela Bay. Due to disagreements among coalition parties, all 3 governments collapsed, and the DA lost control of Johannesburg and Nelson Mandela Bay. These disadvantages highlight the challenges in governance and party dynamics within a proportional representation system. Next. Page. New Nation Movement NPCV President of the Republic of South Africa, 2020 Case Summary. Issue. The Constitutional Court found that the party proportional representation electoral system was unconstitutional as it infringed Section 19(3)(b) of the Constitution, which grants adult citizens the right to stand for public office. Legal question: whether the right to stand for public office under Section 19(3)(b) should be interpreted narrowly, only as a member of a political party, or broadly, including independent candidates. Court's findings. 1. Broad interpretation of Section 19(3)(b). The court held that Section 19(3)(b) should be interpreted broadly, allowing citizens to stand as independent candidates. The narrow interpretation, which only permitted standing as a member of a political party, was found to conflict with other constitutional rights. 2. Section 19(1), Right to make political choices. The right to make political choices, Section 19(1), was violated by the narrow interpretation, which conflicted with the broader right not to be forced to join a political party. Interpretation of Constitution. The Constitution must be interpreted in a manner that harmonizes its provisions rather than creating conflicts between them. 3. Section 18, Right to freedom of association. The narrow interpretation infringed the right to freedom of association, Section 18, which includes the negative right not to associate with a political party. Coercing individuals to join political parties, even if it is easy or cheap to do so, was found to be a violation of dignity and freedom of conscience. 4. Section 157(2) A conflict. The court rejected the argument that Section 157(2)(a), which allows national legislation to prescribe a party system at the local government level, justifies restricting independent candidates at the national level. Resolution. Section 157(2)(a) was considered an internal modifier applicable to municipal elections only, not conflicting with the broad interpretation of Section 19(3)(b) for national and provincial elections. Outcome. Declaration of unconstitutionality. Section 57(a) and Schedule 1(a) of the Electoral Act 73 of 1998 were declared unconstitutional because they prevented independent candidates from standing for election to the National Assembly and provincial legislatures. Prospective effect. The invalidity was prospective, only effective in the future, and suspended for 24 months to allow Parliament time to amend the Electoral Act. This ruling expanded the right to stand for public office, affirming that independent candidates must be allowed to run for national and provincial elections, reinforcing the broader democratic principles of participation and association. Next page. Remedying the defect in the Electoral Act. Majority finding: the Electoral Act was found unconstitutional for not permitting independent candidates to stand for election to the National Assembly and provincial legislatures. Parliament's responsibility: the court did not provide specific instructions on how to remedy the defect, citing the separation of powers doctrine, which assigns the responsibility for remedying constitutional defects to Parliament. Options for Parliament: 1. Fundamental change to electoral law. Parliament could create defined constituencies where adult citizens could stand for election either as individuals or as members of political parties, while maintaining the proportional element of the system. Example: 200 out of 400 National Assembly seats could be constituency-based, with the remaining 200 seats allocated to candidates nominated by political parties in proportion to votes received. 2. Tweak existing system. Alternatively, Parliament could make minor adjustments to the current system to allow individual adult citizens to run for election alongside political parties, thus enabling independent candidates to participate in national and provincial elections. Next page. The right to vote in the Electoral Commission. Section 19(3). The Constitution guarantees the right to vote to every citizen. Only citizens above the age of 18 qualify to vote, excluding children. Electoral Commission. The Electoral Commission, also known as the Independent Electoral Commission, is established under Section 181(1)(f) of the Constitution. Its responsibilities include managing national, provincial, and municipal elections in accordance with national legislation, ensuring that elections are free and fair, declaring election results within a prescribed period. Independence of the Electoral Commission. The Constitution guarantees the independence of the Electoral Commission. Independent Electoral Commission v. Langburg Municipality. The court confirmed that the Electoral Commission, while an organ of state, is independent of the government and cannot be classified as a government department or administration. Financial and administrative independence. Financial independence. The Commission must have access to funds necessary to perform its duties. Parliament must consider the Commission's funding needs and allocate funds rationally. Administrative independence. The Commission must have control over its internal operations and staffing, and cannot be directed by other government departments, such as the Department of Home Affairs. The right to vote is a fundamental right. August and another v. Electoral Commission. The right to vote under Section 19(2) is unqualified and cannot be removed arbitrarily. This imposes a positive obligation on the Electoral Commission to ensure that eligible voters are registered and able to vote. Sachs J. The vote is a badge of dignity and represents the importance of every citizen in the democratic process. New National Party. The court reaffirmed that the right to vote is fundamental to democracy and requires adequate arrangements for its effective exercise. Failure to fulfill obligations. In the August case, the Commission's failure to ensure that prisoners could register and vote was a violation of its obligations to uphold the right to vote. Next page. Limitations on the constitutional right to vote. Disenfranchisement of prisoners. Following the Constitutional Court's judgment in August, Parliament amended the Electoral Act prior to the 2004 national elections, preventing prisoners serving sentences without the option of a fine from registering and voting. This effectively disenfranchised these prisoners. The constitutionality of this amendment was challenged in Minister of Home Affairs v. National Institute for Crime Prevention and the Reintegration of Offenders, NICRO. The limitation of the right to vote. The primary issue was whether the amendment to the Electoral Act constituted a justifiable limitation of the right to vote under Section 36 of the Constitution. Government's argument: the limitation was intended to preserve the integrity of the voting process. Special voting arrangements, mobile voting stations or special votes, would strain resources and pose risks. The Constitutional Court's response: the state failed to provide adequate evidence to support the claims of logistical difficulties and costs. The court found that providing mobile voting stations for prisoners sentenced without the option of a fine would not place an undue burden on resources. The court emphasized that limitations on voting rights must be justifiable and narrowly tailored to achieve an important purpose. South Africans living abroad. The Constitutional Court also addressed whether South Africans living abroad have the right to vote, particularly regarding special votes. In Richter v. Minister for Home Affairs and a party in another v. Minister for Home Affairs, the court ruled that South Africans living abroad have the right to vote if registered. Section 33 of the Electoral Act, which restricted special votes for citizens abroad, was deemed unconstitutional and invalid. The ruling allowed citizens who were registered and abroad during the 2009 elections to vote in national elections but not provincial elections, provided they notified the chief electoral officer by March 27, 2009 and identified the embassy, high commission, or consulate where they would vote. Judgment by Oregon J. The right to vote has symbolic and democratic value. Registered voters abroad should not face unconstitutional limitations in the Electoral Act. Judgment by Nkobo J. Voters who were not registered while abroad could not vote. The limitations on voting for South Africans abroad had been in effect since 2003, and the applicants had failed to explain their delayed challenge. Nkobo J emphasized that the applicants were responsible for their own situation, as the registration provisions had been known since 2003. Significance of the cases. These cases highlight the importance of ensuring that the electoral process is accessible to all citizens, reinforcing the state's responsibility to create an environment conducive to democracy and the right to vote. Next page. Eligibility for election to the National Assembly. Qualifications for membership. Citizens who are eligible to vote for the National Assembly, NA, are generally eligible to become members, except for certain categories. Ineligible persons. Public servants, those appointed by or in the service of the state receiving remuneration, except President, Deputy President, Ministers, and Deputy Ministers. Permanent delegates to the NCOP, members of provincial legislatures, or municipal councils. Unrehabilitated insolvents. Those declared of unsound mind by a court. Those convicted of an offense and sentenced to more than 12 months imprisonment without the option of a fine, either within or outside South Africa, for offenses that would be punishable in South Africa. Loss of membership. A member who is absent from the NA without permission for an extended period, over 15 days. A member who ceases to be part of the party that nominated them will lose their seat. Members are beholden to their political party and may lose their seat if they cross the floor or are expelled. Duration of the National Assembly, sittings, and dissolution. Term of the National Assembly. The NA is elected for a 5-year term but can be dissolved earlier under certain conditions. Early dissolution. 1. Resolution for dissolution. The President must dissolve the NA if a resolution to dissolve is passed by a majority vote and 3 years have passed since the last election. Section 51. The President must set the election date within 90 days. Strategic dissolution. Parties may dissolve the NA to secure a political advantage, for example, post-popular events. 2. Vacancy in the office of the President. If the President dies, resigns, or is removed, and the NA fails to elect a new President within 30 days, the acting President must dissolve the NA and call a new election within 90 days. Section 52. First sitting after an election. The first sitting of the NA must occur within 14 days after the results are finalized, at a date determined by the Chief Justice. At the first sitting, the President is elected from the members, along with the Speaker and Deputy Speaker. Sittings and recess. The NA may determine the time and duration of its sittings and recess periods. The President can summon the NA for extraordinary sittings for special business. The NA can sit away from Cape Town under 2 conditions. 1. Emergency. The Speaker may direct the sitting to be held elsewhere for reasons of security or convenience, after consulting relevant parties. NA Rule 43(1). 2. Public interest or convenience. The NA can resolve to sit elsewhere, with justification for the change. NA Rule 43(2). Next page. Powers and functioning of the National Assembly. Main functions of the National Assembly, NA, Section 42(3) of the Constitution. Elects the President. Serves as a national forum for public consideration of issues. Considers and passes legislation, alongside the NCOP. Scrutinizes and oversees executive action, holding the executive accountable. Legislative power. The NA can consider, pass, amend, or reject any legislation, except money bills. It must provide mechanisms to ensure accountability from all executive organs of state in the national sphere of government and maintain oversight of national executive authority and implementation of legislation. Quorum and voting requirements, Section 59. Bills or amendments to bills, a quorum of 201 members is required to vote. Other questions, a quorum of 134 members is required. If there is no quorum after a short interval, 5 to 15 minutes, the presiding officer, Speaker or Deputy Speaker may suspend the proceedings or postpone the decision. Majority voting. Most questions are decided by a majority of votes cast by those present. Impeachment of the President or amending the Constitution requires a two-thirds majority, at least 266 members. Amendment to Section 1 of the Constitution requires a 75% majority. Presiding officers voting. The presiding officer, Speaker or Deputy Speaker, does not have a deliberative vote but must cast a deciding vote when votes are tied. The presiding officer may vote when a two-thirds majority is required. Attendance of executive members. The President, cabinet members, and deputy ministers, who are not NA members, may attend and speak in the NA but cannot vote. Functioning of the National Assembly. Internal control. The NA has the power to determine and control its internal proceedings, procedures, and rules, ensuring accountability, transparency, and public involvement. Section 57(1). Role of the Speaker. The Speaker, or Deputy Speaker in their absence, presides over debates in the NA and maintains discipline. The Speaker must be impartial and act in a manner similar to a judge, ensuring fairness and transparency. The Speaker is responsible for upholding the rights and privileges of NA members and is also the administrative head of Parliament. The Speaker's powers must serve the purpose of advancing democracy, as affirmed by the Constitutional Court in United Democratic Movement v. Speaker of the National Assembly. Public meetings. NA members can ask questions of the Cabinet and engage in debates. The NA serves as a platform for political debates and speeches by the President, Cabinet members, and party leaders. Committees. Much of the serious work in the NA is conducted in committees, where detailed scrutiny of issues takes place. Next page. The role of the Speaker. Impartiality of the Speaker. The Speaker must be impartial both inside and outside the legislature, a standard derived from the Westminster tradition. This impartiality includes not participating in debates and refraining from an active role in party politics. Case, Tlawama and others v. Mbete, Speaker of the National Assembly, 2015. Opposition parties, Agang, COPE, UDM, sought to remove the Speaker from office, claiming her bias towards the ANC. They argued that the Speaker's active involvement in ANC politics and her position within the party compromised her impartiality, making her unsuitable for office. Court's decision. The Western Cape High Court rejected the application. The court acknowledged the UK model, where the Speaker must sever ties with political parties, but noted that South Africa's parliamentary system, proportional representation, does not require the Speaker to sever party ties. The Constitution and the rules of the National Assembly do not forbid the Speaker from participating in party politics. The Speaker's involvement in the ANC-NEC did not invalidate her impartiality in her official duties. Key findings. No constitutional or statutory impediment to the Speaker holding leadership positions in her party or participating in party activities. The Speaker's party affiliation does not automatically imply a lack of impartiality. The Speaker is allowed to be an office-bearer of a political party and may campaign for political rights. Committees in the National Assembly. Establishment of committees, Section 57(2)(a) and (b). The Constitution mandates the establishment of committees to process legislation and oversee executive actions in various portfolios. Minority parties must be represented in committees according to democratic principles, as per the rules of the Assembly. Committee membership. Committees are typically formed based on the proportional representation of political parties in the NA. The majority party in the NA usually has a majority on each committee and can outvote minority parties on issues. Role of committees. Political parties appoint members to committees, and the majority party designates the chairpersons. The Standing Committee on Public Accounts is traditionally chaired by a member of the opposition. Committee chairs can be removed if their party decides to do so. Influence of political party leadership. Party leadership has significant influence over committee members, including the appointment and removal of members and chairs. Members may act to ensure they are appointed to desirable committees or to avoid actions that would harm their chances for future appointments. Committee powers. Committees have broad powers, including the ability to summon witnesses to testify before them. Next page. The National Council of Provinces, NCOP, composition and function. The NCOP is the second chamber of South Africa's bicameral parliament, created to represent provincial interests at the national level. Its role includes participating in the national legislative process and providing a forum for discussing issues affecting provinces. NCOP differs from provincial legislatures, as it represents provinces at the national level rather than passing provincial laws, exclusive and concurrent functional areas. Role in government. Then COP ensures that national government is responsive to provincial interests and involves provinces in national policy discussions. Then COP is designed to strengthen cooperative government, ensuring that provincial interests are adequately represented and integrated into national legislation. Court's view, Doctors for Life. Described as performing functions similar to the National Assembly, NA, but with a focus on the provinces. Then COP ensures cooperative governance by linking provinces to national governance and ensuring national policies reflect provincial concerns. Comparison to the German Bundesrat. Then COP shares many structural characteristics with the Bundesrat, German Council of State Governments. Like the Bundesrat, then COP represents provincial governments in the national legislative process, with members appointed and subject to recall by provincial governments. Composition of the COP. The COP has 90 members, consisting of 10 delegates from each of the 9 provinces. Delegates are allocated proportionally based on the strength of parties in the provincial legislature. For example, if a party has 60% of seats in a provincial legislature, it will hold 60% of the provincial MCOP delegation. Types of delegates. Special delegates, 4 special delegates per province, including the premier or a delegate from the provincial legislature. The premier or delegate leads the provincial delegation. Permanent delegates, 6 permanent delegates per province, also selected from the provincial legislature. Term inchangeability. Special delegates are not appointed for fixed terms and can change based on the provincial legislature's decisions and the issues at hand. For example, a delegate with specific knowledge may be appointed for particular matters. Key points. Then COP represents provincial interests at the national level and operates as a linking mechanism between the national government and provinces. It shares similarities with the German Bundesrat, focusing on cooperative government and ensuring both levels of government work together. Its membership is based on proportional representation from each province, ensuring broad provincial involvement in national lawmaking. Next page. Composition of the National Council of Provinces, NCOP, permanent delegates. Selection. 6 permanent delegates per province are selected based on party affiliation to ensure proportional representation of political parties in the COP. Difference from special delegates. Unlike special delegates, permanent delegates cannot serve simultaneously in the provincial legislature. They are either appointed from the provincial legislature or from non-legislature party members, in which case they forfeit their legislative seats. Function. Permanent delegates ensure continuity and stability by maintaining a continuous political presence at the COP, with at least 6 members from each province permanently stationed in Parliament. Recall and removal. A permanent delegate may lose membership if the provincial legislature passes a motion of no confidence, but the delegate can only be removed if the nominating party recalls them. Factors influencing COP operation. The decision to replace the Senate with the COP was challenged, arguing that it reduced provincial power. The Constitutional Court upheld the COP structure but noted challenges in evaluating its practical impact due to differences in powers, methods of representation, voting patterns, and party influence. The larger political context and the dynamics of constitutional engineering. Powers of the COP. The powers of the COP depend on the impact of the legislation on provincial interests. For non-provincial issues, delegates vote based on party preferences. For legislation affecting provinces, each delegation casts a single vote based on a mandate from their provincial legislature. Certification of the Constitution. The COP is a council of provinces, and its voting system ensures provincial legislatures directly influence national legislation. Operational challenges. Mandate and information issues. Provinces struggle to provide informed mandates to the COP due to limited resources, poor communication, and time constraints for responding to draft bills. Weak political links. The political connection between COP members, national and provincial legislatures, and provincial executives is often weak, hampering the COP's effectiveness as a bridge. Comparison with Germany's Bundesrat. Unlike the Bundesrat, where members are provincial executives, the COP's members are not involved in executive intergovernmental relations. COP's limited influence. The COP is often considered a less powerful chamber due to the dominance of the National Assembly, NA. Most cabinet ministers serve in the NA, and the COP lacks a formal mandate to hold the cabinet accountable. Despite its limited executive oversight, the COP plays a crucial role in lawmaking. Broad powers under Section 69. The COP and its committees have significant powers, including summoning individuals to provide evidence or documents, requiring institutions or individuals to report, enforcing compliance with summonses, receiving petitions and submissions from interested parties. Key points. Permanent delegates provide stability and proportional party representation but can be recalled by the nominating party. The NCOP's operational effectiveness is influenced by practical challenges such as time constraints, weak political links, and poor communication. The NCOP plays a critical role in legislative processes but lacks significant executive oversight and political power compared to the National Assembly. Despite its limitations, the NCOP holds broad investigatory and reporting powers. Next page. Role of strict party discipline in the effectiveness of the NCOP. Marathon Demarcation Forum case. Background: the Gauteng Provincial Legislature mandated its NCOP delegation to support a constitutional amendment eliminating cross-border municipalities, conditional on the Marathon municipality remaining in Gauteng. Mandate shift: after technical issues arose with the constitutional amendment bill, the Gauteng delegation changed its stance and voted in favor of the bill. This decision was later challenged by the applicants, who argued the delegation's vote did not align with the mandate from the Gauteng Provincial Legislature but was influenced by the ANC's National Executive Committee, NEC. Constitutional Court ruling: the court found insufficient evidence to confirm that the NEC's policies influenced the voting, and rejected the argument that the NCOP delegation's mandate was altered solely due to ANC instructions. Impact of strict party discipline. Party discipline and influence. The case highlights the potential impact of strict party discipline on the NCOP's ability to represent provincial interests. Political parties, particularly the ruling party, can influence the decisions of NCOP delegations and provincial legislatures by enforcing adherence to leadership instructions. Delegations mandate. In situations where the ruling party controls both the national and provincial legislatures, party discipline can lead to provincial delegations voting in line with national political consensus, rather than prioritizing provincial interests. Challenges to provincial interests. When sensitive political issues are involved, strict party discipline can prevent provincial delegations from challenging the national party's stance, undermining the NCOP's effectiveness in safeguarding provincial concerns. Less sensitive issues. In areas that are politically less sensitive or more technical, the strict adherence to party discipline may not entirely hinder provincial delegations from representing local interests. Key points. The Marathon case illustrates the potential conflict between provincial mandates and national party directives, especially in situations involving sensitive political issues. Strict party discipline is a significant factor in the NCOP's ability to effectively represent provincial interests, with majority parties exerting influence over provincial delegations. The degree of party control at both the national and provincial levels can dictate whether provincial concerns are prioritized or overshadowed by national political agendas. Next page. Procedures, internal arrangements, and committees of the NCOP. Constitutional requirements. The Constitution mandates the election of a chairperson and 2 deputy chairpersons of the NCOP. NCOP has the autonomy to establish its own internal arrangements and procedures. NCOP must create committees to oversee its functions, in accordance with its rules. Voting procedures. 1 vote per province. Each province typically has 1 vote in the NCOP, cast by the head of the delegation. A majority is achieved when 5 delegations support a decision. Voting on non-provincial bills. For bills that do not affect the provinces, for example, non-Schedule 4 and 5 bills, delegates vote individually. A quorum of 1/3 of delegates is required, and a decision is made by a majority of those present. Mandating procedures. The Mandating Procedures of Provinces Act provides the framework for how provincial legislatures authorize their delegations to cast votes on their behalf. However, in practice, the majority party in the provincial legislature often determines how the provincial delegation votes. Majority requirements. In most cases, an absolute majority is required for decisions, with 5 out of 9 provinces needed to agree. Participation of minority parties. When the NCOP acts as a representative of the provinces, all provinces must participate in a democratic manner. For lawmaking not affecting provinces, minority parties are entitled to participate. NCOP's permanent nature. The NCOP cannot be dissolved and operates as a perpetual body. Terms of delegates. The terms of permanent delegates are tied to the provincial legislature they represent and may be recalled by the provincial legislature. Special delegates are appointed temporarily and generally serve for short periods. Key points. The NCOP has the flexibility to establish its own procedures and committees but must adhere to constitutional voting rules. Voting depends on the nature of the bill and whether it affects the provinces. The NCOP operates as a continuous body, but the tenure of delegates is linked to provincial legislatures, with recall provisions. Next page. Functions of Parliament. 4.6.1 Introduction. Main function. Parliament's primary function is to pass national legislation in the form of Acts of Parliament. Symbolic role. Parliament also serves as a national forum for public debate on important issues, providing a platform for political parties to present views and engage in debate. Special role of the National Assembly. NA. The NA holds a special role as a check on executive authority. This is due to the NA's power to appoint and dismiss the President, making it essential for the President and Cabinet to maintain the confidence of the NA. Main functions of Parliament. Both the NA and the NCOP perform the following functions. Provide a forum for debate on important issues. Hold the executive accountable to Parliament. Exercise oversight over national authority and other state organs. Pass national legislation. 4.6.2 National Forum for Public Consideration of Issues. Role as a national talk shop. Transparency and accountability. Parliament must operate transparently, ensuring that the public and media can access its proceedings unless a justified reason exists to exclude them. Public participation. Parliament ensures that ordinary individuals and institutions can present their views on issues by submitting written comments or making oral presentations during parliamentary proceedings. Platform for debate. Parliament provides a space for elected representatives to deliver speeches, debate policy issues, and engage with the President on political matters. This includes debating important and sometimes emotional issues in a rational and calm manner. Educational function. Parliament, through media reporting, serves an educational role, encouraging citizens to engage in democracy, respect differing views, and understand the importance of democratic participation. Rules and procedures. National Assembly, NA, members can propose topics for discussion or resolutions, with the option of a debate. They may also request the Speaker to schedule urgent matters for immediate discussion. National Council of Provinces, NCOP, delegates may request the chairperson to allow discussions on matters of public importance, particularly those affecting the provinces or their interests. Key points. Parliament is tasked with passing legislation, acting as a national forum for debate, overseeing the executive, and ensuring accountability. It plays a role as a transparent, accountable platform, promoting public participation in the democratic process. The rules of the NCOP provide mechanisms for debate and urgent discussions, allowing elected representatives to propose and address important national matters. Next page. 4.6.3 Holding the executive accountable to Parliament. Overview of accountability. Parliament's role. The Constitution establishes a system where members of the Cabinet are accountable to Parliament and must regularly report on their actions. Constitutional obligation. Holding the President and the Executive accountable is not discretionary but a constitutional duty of Parliament, as affirmed by the Constitutional Court. This includes the duty to implement mechanisms that ensure accountability. Key case law. United Democratic Movement v. Speaker of the National Assembly. Parliament must oversee the President and Cabinet's performance, ensuring they are accountable for their use of state power and resources. If accountability mechanisms fail, Parliament may resort to extreme measures like impeachment. Economic Freedom Fighters v. Speaker of the National Assembly. The Constitutional Court ordered the NA to hold the President accountable after the Public Protector found the President violated the Constitution. The NA failed to take appropriate action, despite a motion for removal, and the court concluded the NA had not fulfilled its constitutional duty. Types of accountability. 1. First aspect, the NCOP can summon individuals, including executive members, to account for their actions. This ensures transparency, responsiveness, and improved government performance. Mechanisms like questioning government officials in the NCOP are crucial for public confidence and democracy. Constitutional provisions, Sections 56 and 69 allow Parliament to summon any person to give evidence or produce documents. If necessary, they can compel compliance through summons. 2. Second aspect, the NA has special powers for democratic control over the executive. While both the NA and COP hold the Cabinet accountable, the NA has additional powers. Motion of no confidence. Section 102(2) of the Constitution allows the NA to pass a motion of no confidence in the President, leading to the resignation of the President and Cabinet members. Political nature. This power is political and can be exercised for political reasons. If the President loses the support of the majority party in the NA, they must resign, and the majority party can ensure this by controlling the vote. Political control. If the President refuses to resign, the majority party will instruct its members to support the motion. Members who oppose the motion will be removed and replaced by those who support it. Summary of key mechanisms. Summons. Parliament can summon individuals to provide evidence or documents, compelling compliance when necessary. Questions. Members of Parliament can ask questions and receive oral answers from key executive members. Motion of no confidence. The NA has the power to pass a motion of no confidence in the President, with political consequences for the executive. Key points. Accountability is a constitutional obligation, not optional, with mechanisms like motions of no confidence and impeachment as ultimate remedies. Parliament holds the executive accountable through both oversight mechanisms, summons, questioning, and remedial powers. Motion of no confidence. The NA has special powers, including the ability to remove the President through a motion of no confidence with majority support. Next page. Holding the executive accountable to Parliament, continued. Constitutional Court ruling on no confidence motions. Mazibuko v. Sisulu and another, the Constitutional Court ruled that neither the majority nor the minority parties in the NA can block the tabling, discussion, or voting on a motion of no confidence in the President. Background: the leader of the opposition proposed a motion of no confidence in the President, but the NA Program Committee was deadlocked, preventing the motion from being scheduled, debated, or voted on. The Speaker supported this delay, citing a lack of consensus. Court decision. The court held that the Constitution requires that a motion of no confidence be considered and voted on without unreasonable delay, emphasizing its importance for democratic hygiene and accountability. The motion is a vital tool for Parliament to scrutinize and oversee the executive. It is central to the democratic, multi-party system established by the Constitution. The roles of the NA cannot deny, delay, or frustrate the tabling of such motions. Principles underlying the motion of no confidence. Vital mechanism. A motion of no confidence ensures that the President and Cabinet remain accountable to Parliament. Section 102(2). The NA has the power to remove the President by passing a motion of no confidence, which would require the President and Cabinet to resign. Constitutional duty. The NA must take prompt and reasonable steps to schedule, debate, and vote on the motion of no confidence when tabled. While the majority party may prevent the motion's success, if the majority loses confidence in the President, the motion will lead to removal. Examples of political influence on the motion of no confidence. Former President Mbeki, he resigned after losing a leadership battle within the ANC. Had he refused, the ANC leadership would likely have instructed the NA to vote for his removal. Former President Zuma, after being recalled by the ANC, Zuma initially refused to resign. The ANC then scheduled a motion of no confidence for February 15, 2018. Faced with this, Zuma announced his resignation on February 14, 2018. Impeachment of the President. Section 89(1). The NA can impeach the President with a 2/3 majority for serious violations of the Constitution, misconduct, or inability to perform office functions. This power is not political but based on objective reasons unrelated to political support. Accountability mechanisms in the NA. Section 55(2)(a). The NA must establish mechanisms to hold the executive accountable. This is a fundamental aspect of the parliamentary system, ensuring that the President and Cabinet remain accountable to the NA, the democratically elected body. Role of Parliament in holding the executive accountable. Attitudes of majority party. The ability of the NA and COP to hold the executive accountable depends on the majority party's commitment to accountability and the role of opposition parties in fulfilling their responsibility. Portfolio committees. These committees play a crucial role in scrutinizing the executive and its actions. Question and answer sessions. MPs regularly pose questions to the President, Deputy President, and Cabinet ministers, holding them accountable for their actions and policies. Ministers are required to provide detailed information on departmental activities, including expenditure and policy justifications. Next page. Accountability of the executive to Parliament. Nash's critique of constitutional accountability. Criticism of accountability model. Nash argues that the South African Constitution's emphasis on parliamentary accountability is flawed. Concept of accountability. He believes that effective accountability is not solely reliant on formal mechanisms such as lawyers, bureaucrats, or accountability experts. Instead, accountability is rooted in active participation in political life, driven by a shared ethical standard among the people. Grassroots accountability versus formal mechanisms. Active participation. Nash highlights that accountability in the South African labor movement during the 1970s and 80s was driven by active community involvement and the collective responsibility of individuals. He argues that accountability becomes meaningful only when people are actively engaged in decision-making and have the power to recall their leaders or alter their mandates. Without such participation, accountability becomes superficial and ineffective, merely a formality, paper accountability. Skepticism towards representative democracy. Neoliberal model. Nash describes the accountability built into the Constitution as a neoliberal model, which offers a facade of democracy but lacks the substance necessary for real democratic participation, diverts key issues away from public political discourse and relegates them to bureaucratic procedures, where they are controlled by elites, particularly those in power. MPs and accountability. Indirect accountability. Nash expresses skepticism about the capacity of members of parliament, MPs, to effectively hold the executive accountable. MPs are indirectly elected based on their party standing, not directly accountable to their individual constituencies. This structure weakens their responsibility to their voters, which Nash argues limits their effectiveness in holding the executive to account. Conclusion. Nash's perspective critiques the constitutional model of executive accountability, suggesting that grassroots engagement and direct democracy are essential to true accountability, rather than relying on formal parliamentary procedures that may not result in tangible consequences for the executive. Next page. Maintaining oversight of national executive authority and other organs of state. Definition and importance of oversight. Oversight versus accountability. Oversight is distinct from accountability but shares similar aims. It involves the informal and formal scrutiny by legislatures of implementation of laws, application of the budget, observance of statutes and the Constitution. It requires day-to-day oversight of the national executive and other organs of state, ensuring proper management and effective service delivery. Oversight mechanism. Scope of oversight. Parliament's oversight function extends to all organs of state at national, provincial, and local levels. Section 239 of the Constitution defines organs of state broadly to include any department or administration in government, any functionary or institution exercising public powers or performing public functions under the Constitution, provincial constitution, or legislation. Examples of organs of state: public universities, Johannesburg Fresh Produce Market, Public Protector, Human Rights Commission, Medical Research Council, and National Lotteries Board. Exclusion: courts and judicial officers are not subject to oversight by Parliament. Oversight through parliamentary committees. Mechanism for oversight. Parliamentary committees, particularly portfolio committees, are responsible for conducting oversight. Committees may request briefings from organs of state or cabinet ministers. Visit organs of state for fact-finding purposes. A key part of this oversight is reviewing the annual reports of organs of state and reports from the Auditor General. Effectiveness of committees. Key factors for rigorous oversight. The effectiveness of oversight depends on the independence, knowledge, work ethic, and political power of committee members. Committees have the authority to investigate and make recommendations on various issues, including budgets, rationalization, restructuring, organization, personnel, and policy formulation. Oversight by the National Council of Provinces, NCOP, NCOP's oversight role. The NCOP has a more defined oversight role, particularly regarding interventions by the national executive at the provincial level and provincial executive interventions at the municipal level. The NCOP must approve Treasury decisions to stop the transfer of funds to provinces, approve presidential declarations of a state of national defense, resolve disputes about the administrative capacity of provinces. Conclusion. Overall importance. Oversight is essential for ensuring the effective management of government departments and for holding organs of state accountable to Parliament and the public. Next page. Passing of legislation. Cooperative government in the lawmaking process. Chapter 3 of the Constitution emphasizes cooperative government, which is essential for the legislative process. Cooperation and communication between national and provincial legislatures, and between the national executive and Parliament, are required for the enactment of laws. The role of the NCOP is crucial in ensuring that provincial interests are considered in national legislation. Doctors for Life case. The Constitutional Court emphasized the importance of involving provinces and local government in the legislative process. Power of Parliament and legislation. Section 44 of the Constitution grants Parliament the power to amend the Constitution, pass legislation on any matter, including those listed in Schedule 4, concurrent national and provincial powers, but excluding those in Schedule 5, exclusive provincial powers, assign powers to other legislative bodies, excluding the power to amend the Constitution, conflict between national and provincial legislation. Section 146 dictates that provincial legislation prevails over national legislation in matters listed in Schedule 4, unless certain conditions are met. Executive influence on legislation. Executive dominance. Most draft legislation, bills, originate from the executive and are tabled in Parliament. However, individual MPs can introduce private members' bills. Section 73(2). Before 2012, opposition MPs faced significant barriers to introducing bills, needing majority approval to proceed. Legislation by non-cabinet ministers. Private members' bills. MPs, even from opposition parties, may introduce bills, but the NA rules required approval from the majority party. Rules invalidated. In Oriani Ambrosini v. Sisulu, the Constitutional Court ruled that the requirement for permission from the majority party was unconstitutional, citing the need for a pluralistic democracy where all voices are heard. This allows MPs to present legislative proposals which are debated critically in portfolio committees before being voted on by the NA. Impact of the court's decision. The Oriani Ambrosini judgment affirmed the right of MPs to introduce bills without needing majority party permission, promoting a more open and deliberative process. This allows MPs to submit constructive proposals beyond an obstructionist role. However, the majority party can still vote against a bill, meaning the majority's decision is typically decisive. Conclusion. Executive dominance in legislation. Despite the opportunity for MPs to initiate legislation, most bills are still introduced by cabinet ministers. Legislative process. Bills are proposed, debated, and passed by Parliament. While opposition MPs can propose alternative legislation, the majority party often holds significant influence in the process. Next page. One small step for Parliament, one giant leap for Oriani Ambrosini. Context of the Oriani Ambrosini judgment. Devo commentary. The judgment is seen as an essential step in improving democratic accountability in South Africa's electoral system. The party proportional system makes it difficult for voters to hold individual MPs accountable, thus diminishing transparency and democratic participation. The Oriani Ambrosini judgment ensures that individual MPs, especially from opposition parties, can propose and debate alternative legislative bills, fostering public engagement. Chief Justice Mogoeng's emphasis. Providing space for alternative legislative proposals helps in public debates and makes the legislative process more transparent. This process ensures that even minority party members can initiate legislation, giving the public a chance to evaluate the merits of bills proposed by both the government and the opposition. Impact on majority party. The majority party still holds the power to approve or reject bills, but the opportunity to debate opposition bills forces MPs to engage seriously with them. Failure to engage responsibly with such proposals could result in voter backlash, undermining the party's support base. On the other hand, if the majority party can effectively challenge the opposition's proposals, it could strengthen its appeal among undecided voters. Challenges in realizing a more relevant parliament. Despite the judgment, the centralized political culture of the ANC and its dominance in South Africa's political system may limit the impact of these changes. The strict party discipline and centralized control over MPs restricts individual initiatives from MPs, even those from opposition parties. Structural and contextual reasons for executive dominance. One-party dominance. Since 1994, South Africa has had a dominant party system, with cabinet ministers initiating most legislation, reflecting the political mandate of the majority party. Proportional representation. MPs rely on party support for retaining their seats, making them unlikely to initiate legislation not approved by their leadership. Highly centralized ANC power is concentrated in the hands of the ANC leadership and the president, resulting in a strong executive influence over the lawmaking process. Role of the Speaker. The Speaker, a member of the majority party, plays a key role in deciding which bills are introduced, reinforcing the dominance of the ruling party. Practical reasons for executive-driven legislation. The executive typically drives legislation to implement the majority party's political agenda. This reflects the democratic mandate given to the governing party by voters, who expect the party to introduce legislation that aligns with its election promises. Standard lawmaking process in South Africa. 1. Policy formulation. Policy is developed through discussions within NEDLAC, party discussions, and cabinet, resulting in a draft bill. 2. Cabinet approval. The draft bill is approved by cabinet and then introduced in parliament by the responsible cabinet minister. 3. First reading. The bill is introduced in the National Assembly, NA, or the NCOP for the first reading. 4. Second reading. The bill is reviewed by the relevant portfolio committee, amended, and subjected to public involvement. 5. Final passage. If approved by both the NA and NCOP, the bill is presented to the President for signature. The President can refer a bill back to Parliament if there are constitutional concerns but cannot veto it outright. Conclusion. The Oriani-Ambrosini judgment marks a significant step toward improving democratic participation by enabling MPs to introduce and debate alternative legislation. However, structural and political factors continue to give the executive considerable influence in the lawmaking process. Next page. Does the President enjoy the power to veto a bill? No general veto power. In South Africa, the President does not have the power to veto a bill based on political disagreement or personal belief that the bill is flawed. The President cannot refuse to sign a bill into law merely because of policy reasons or non-constitutional flaws. Limited veto power. Section 79 of the Constitution. The President's veto power is narrow and exists only in specific circumstances concerning the constitutionality of a bill. 2. Assent to a bill. Section 79(1) of the Constitution mandates the President to either assent to a bill passed by Parliament or, if there are constitutional concerns, refer it back to Parliament for reconsideration. 3. Constitutional review. If the President has reservations about constitutionality, they may refer the bill to the Constitutional Court for a decision under Section 79(4)(b). Duty to sign. When the President does not have constitutional reservations, Section 237 of the Constitution requires the President to sign the bill diligently and without delay. Delaying a bill or referring it back to Parliament due to perceived flaws not related to constitutionality would be unconstitutional. This could be viewed as usurping parliamentary powers, as Parliament is the only directly elected branch of government. Such actions could lead to a constitutional crisis, undermining the separation of powers between the executive and the legislature. Next page. Lawmaking process and bill categorization. 4 categories of bills. The Constitution distinguishes between 4 types of bills. 1. Bills amending the Constitution, Section 74 bills. 2. Ordinary bills not affecting provinces, Section 75 bills. 3. Ordinary bills affecting provinces. 4. Money bills. Importance of bill classification. Tagging a bill is crucial as it determines the procedure to follow. Different categories have different requirements, some of which are more onerous than others. Tagging mechanism. The Joint Tagging Mechanism, JTM, comprising the Speaker and Deputy Speaker of the NA and the chairpersons of the NCOP, is responsible for classifying bills. Test for tagging, Tongue-own case. The Constitutional Court outlined a test for tagging. The substantial measure test is applied, which focuses on whether the provisions of the bill substantially affect areas the Constitution empowers provinces to legislate on. This test differs from the pith and substance test, which determines legislative competence, and is used for tagging purposes only. Purpose of tagging. Tagging determines how a bill affects the provinces and the NCOP's role in the lawmaking process. It influences whether a bill will be passed by a simple majority or requires a supermajority. Tagging ensures that the voice of the provinces is considered in relevant legislation. Categories of bills and procedures. 1. Section 74 bills, constitutional amendments. Special procedure. Amendments to the Constitution require special majorities. Amendments to founding provisions need 75% of NA members and 6 of 9 provincial delegations in the NCOP. Amendments to the Bill of Rights require 2/3 of NA members and 6 of 9 provincial delegations in the NCOP. Ordinary constitutional amendments can be passed with 2/3 of the NA, however, if it affects the NCOP, provincial boundaries, or powers, the approval of 6 provincial delegations is needed. Amendments affecting provinces require the approval of concerned provincial legislatures. 2. Section 75 bills, ordinary bills not affecting provinces. These bills cannot be introduced in the NCOP, only in the NA. The NCOP's role. The NCOP votes on these bills, but each delegate has 1 vote, and decisions are made by a majority vote with a quorum of 1/3 of delegates. If the NCOP approves the bill, it is sent to the President. If the NCOP rejects or amends the bill, it returns to the NA for reconsideration. The NA can override the NCOP's amendments, passing the original bill to the President for assent. 3. Money bills. These are treated differently and have specific processes that are not outlined in detail in this section. Next page. Endorsement and passage of bills. Endorsement by the National Assembly, NA. The NA may either endorse the amendments made by the NCOP by passing the same version of the bill, after which it will be sent to the President. Choose not to proceed with the bill, causing it to lapse. Section 75 versus Section 76 bills. Section 75 bills can be passed by the NA without the support of the NCOP. The NA has more power in the passage of Section 75 bills, which may be significant if the majority party in the NA does not have a majority in the NCOP. Section 76 bills. These bills affect the provinces and therefore give the NCOP a more powerful role. The NCOP has a substantial influence over the passage of these bills, as it represents provincial interests. Procedure for Section 76 bills. Bills affecting provinces, tagging. Bills affecting Schedule 4 functional areas or those intervening in Schedule 5 matters are tagged as Section 76 bills. If a bill deals with matters related to the seat of Parliament or other financial matters affecting provinces, it is similarly tagged as Section 76. Introduction and passage. Section 76 bills can be introduced in either the NA or the NCOP. After passing in one house, the bill is sent to the other house, the second house, for further action. If the second house passes the bill without amendments, it is submitted to the President. If amended, the bill returns to the first house for reconsideration. Mediation Committee. If the two houses cannot agree on the bill, it is referred to a mediation committee, which consists of 9 members from the NA, proportional representation, 9 delegates from the NCOP, 1 per provincial delegation. The mediation committee can make a decision only if 5 representatives from both the NA and NCOP agree on a version of the bill. If an agreement is not reached within 30 days, the bill lapses unless the NA passes it with a 2/3 majority. Override power. If the mediation committee agrees on a version of the bill, the second house must approve the bill for it to proceed to the President. Override. If the bill was introduced in the NA and is not supported by the NCOP, the NA can override the NCOP with a 2/3 majority. The NCOP cannot override the NA's decision in the same way. Impact of the NCOP in Section 76 bills. More powerful role. The NCOP has greater influence over Section 76 bills compared to Section 75 bills, as it represents the interests of provinces. The NCOP can block or influence legislation that affects provincial matters, ensuring that the NA cannot overpower the provinces. Cooperative government. These mechanisms aim to facilitate cooperation and consensus between the two houses of Parliament, ensuring that the NA, representing the national electorate, does not dominate the NCOP, which represents the provinces with equal power for each. Equal representation of provinces. Provinces, regardless of their size, are represented equally in the NCOP through their delegations, ensuring fairness and protection of provincial interests. Next page. Impact of different majority parties controlling the NCOP. Scenario. When different majority parties control the National Assembly, NA, and the National Council of Provinces, NCOP, the legislative process, especially for Section 76 bills affecting provinces, becomes more complex. For instance, a party could have a national majority, for example, 53% of the votes, in the NA, but lose control of at least 5 provinces to another party or coalition, giving the opposition party a majority in the NCOP. Legislative impact. If a Section 76 bill, for example, one proposed by the Cabinet, is supported by the majority in the NA but opposed by the NCOP, the bill cannot become law unless the opposition, controlling 5 provincial delegations, agrees to it. The opposition in the NCOP can effectively veto the bill due to its control over the majority of provincial delegation votes. Section 77 and money bills. Money bills. Section 77 bills, money bills, are related to taxes, levies, duties, and allocation of funds for state spending, for example, the annual budget. These bills are introduced by the Minister of Finance and follow a specific procedure outlined in Section 75. Amendment of money bills. Special procedures. The Money Bills Amendment Procedure and Related Matters Act lays out procedures for amending money bills, acknowledging the technical complexity of the budget. Parliament is restricted from amending the budget in the same way as other bills to avoid financial uncertainty. Presidential assent. Procedure for presidential assent. After a bill passes through Parliament, it must be submitted to the President for assent as per Section 79 of the Constitution. The President can refer a bill back to the NA if there are constitutional reservations about its content, specifying the issues at hand. The President cannot veto a bill for political reasons. Their power is limited to constitutional reservations. Reconsideration process. If the President's reservations are addressed by Parliament, they must sign the bill into law. If the reservations are not accommodated, the President may refer the bill to the Constitutional Court for a ruling on its constitutionality. _ Constitutional Court ruling on presidential reservations. Ex-party President of the Republic of South Africa, in reconstitutionality of the Liquor Bill. The Constitutional Court established key principles regarding the President's power to refer a bill to the court. The court only reviews the reservations expressed by the President, not the entire bill. The court does not need to assess every provision of the bill for constitutional compliance. The ruling on the bill's constitutionality does not preclude future challenges to provisions of the bill once enacted, except for those provisions already reviewed. Post-enactment constitutional challenge. Even after a bill becomes an act of Parliament, its constitutionality can still be challenged in the Constitutional Court by 1/3 of MPs within 30 days of the President's assent. The Constitutional Court has the authority to suspend the implementation of the Act while reviewing its constitutionality if the interests of justice require it and there is a reasonable chance of success in the challenge. _ Summary of key mechanisms. Different majority control. Then CUP can block or veto Section 76 bills if it holds the majority of votes from the provinces, even if the NA supports the bill. Money bills. Special procedures exist for money bills, especially regarding the budget, to prevent financial uncertainty. Presidential assent and referrals. The President can refer a bill back to Parliament over constitutional reservations. If unresolved, the bill can be sent to the Constitutional Court. Constitutional Court. The court can review constitutional challenges to laws, even post-enactment, but only considers the President's specific reservations. Next page. Delegation of legislative powers to executive or other legislatures. Section 44(1)(a), 3, of the Constitution. Parliamentary authority. Parliament can assign its legislative authority, except the power to amend the Constitution, to other legislative bodies in different spheres of government, such as provincial legislatures and municipal councils. This allows Parliament to delegate matters to provincial legislatures when it believes that they may be better equipped to handle specific issues, even if those issues fall outside the exclusive or concurrent areas for provincial legislation. Delegation to the executive. Delegating powers to the executive. Delegation to the executive is often necessary because Parliament may not be able to deal with all the detailed provisions regarding the implementation of laws. The Constitutional Court and Executive Council of the Western Cape Legislature v. President acknowledged the practical need for such delegation, emphasizing that Parliament cannot be expected to handle all regulatory details. Limits on delegation. Delegation of legislative power is permissible but has limits. Subordinate regulation. Parliament can delegate subordinate regulatory authority, for example, to make regulations or proclamations within a framework of an empowering statute. Plenary legislative power. Parliament cannot delegate plenary legislative power, the power to create original laws, to the executive. This would breach the separation of powers doctrine, which requires that each branch of government exercise its allocated powers. Distinction between subordinate and plenary legislation. Subordinate legislation. This refers to detailed rules and regulations made under an enabling statute passed by Parliament. Examples include presidential proclamations or ministerial regulations. Plenary legislation refers to the original lawmaking power of Parliament to make laws that are not tied to a previously enacted statute. Delegating plenary power would give another body the authority to create laws independently, which the Constitution prohibits. Constitutional Court's view on delegation. Case of Executive Council of the Western Cape. The Constitutional Court ruled that Parliament may not delegate its primary lawmaking powers to the executive. This decision was based on the separation of powers principle. The President had been delegated the power to amend the Local Government Transition Act through proclamation, which the court found unconstitutional. The court emphasized that while Parliament can delegate subordinate legislative authority, it cannot delegate the power to amend or create primary legislation. Conclusion. Delegation of subordinate legislative powers, for example, making regulations, is permissible for the effective implementation of laws, but Parliament cannot delegate its plenary legislative powers to the executive, as this would violate the separation of powers principle. Next page. Parliament cannot delegate its plenary lawmaking power to the President. Case, Justice Alliance of South Africa v. President of the Republic of South Africa. Background. Section 176(1) of the Constitution states that the term of office for a constitutional court judge is 12 years, except when extended by Parliament through legislation. The Judges' Remuneration and Conditions of Employment Act allowed the President to extend the Chief Justice's term if requested by the President. The President attempted to extend the term of Chief Justice Sandile Nkobo, relying on the above provision. This delegation of power was challenged in court, and the court ruled the delegation unconstitutional. Court's ruling. Core legislative function. The court emphasized that Parliament cannot delegate its essential legislative functions, such as extending the term of office of the Chief Justice, which affects judicial independence and the separation of powers. This power was viewed as central to the tenure of judicial office and must be exercised by Parliament, not the President or the Executive. Judicial independence. The court noted that judicial independence is vigorously protected through specific provisions regulating judicial appointments. The Chief Justice, being at the top of the judiciary, requires the same protection. Separation of powers. Section 8A of the Act, which allowed the President to extend the Chief Justice's term, violated the separation of powers and judicial independence by allowing the executive to influence the judiciary's tenure. Parliament's role. The court clarified that Parliament could extend the term of office of constitutional court judges, but it must pass legislation that applies to all judges, rather than delegating this decision to the President. Conclusion. Delegation limitations. The case reinforced the view that Parliament may not delegate its plenary legislative power to the President or Executive, especially in matters affecting the independence of the judiciary or the core functions of the legislature. Proper legal route. The case also underscores the importance of following the correct legal procedure. Had Parliament extended the term of office for all judges, it would have been constitutional, and the Chief Justice could have continued his term. Next page. Summary. The structure and functions of Parliament. Bicameral Parliament. National Assembly, NA, directly elected, represents the people, and uses a pure proportional representation electoral system. Holds more power, including the ability to elect and dismiss the President and executive members. National Council of Provinces, NCOP, indirectly elected, represents provincial interests. Comprises provincial delegates, 6 permanent and 4 special from each provincial legislature. Functions of Parliament. Provides a forum for debate. Holds the executive accountable and exercises oversight. Passes national legislation. Power dynamics. The NA is more powerful because it is directly elected and has a stronger role in holding the executive accountable. Rights and privileges of MPs. MPs have rights like freedom of expression in Parliament and protection from defamation laws, ensuring they can perform their duties without fear of legal consequences. Committees of Parliament. Portfolio committees are key for overseeing specific government departments. MPs can ask questions of the executive, and committees can summon the executive and officials to testify. Legislation process. Government departments, initiated by the relevant minister, normally formulate bills. Opposition party members can propose bills, but the majority party typically controls the legislative agenda. Bills are first reviewed in portfolio committees which can amend them before they are presented to the NA-NCOP for approval. Public participation. The public can participate in the lawmaking process by making written or oral submissions to portfolio committees. The power to pass legislation. Joint taking mechanism. Determines procedural handling of bills. Bills are categorized into sections 74, 75, 76, and 77, each with specific procedures. Amendments to the Constitution require enhanced majorities. After both houses pass the bill, it is sent to the President for signature. The President can refer it back for constitutional concerns or send it to the Constitutional Court for review. Next page. 5. The separation of powers in the national executive. 5.1 Introduction. Executive authority, vested in the President and the national executive, which includes the Deputy President, cabinet members, and deputy ministers. Unlike Parliament, which is composed of members from all political parties with seats in the National Assembly, NA, the national executive is typically made up of members from the majority party or a coalition of parties. Distinction between executive, public administration, public service, and the state. Executive, composed of elected or appointed politicians who form the government for the duration of the NA's life. Public administration includes officials carrying out day-to-day government tasks and implementing political decisions. Public service, more specific, consists of employees of government departments at national and provincial levels. State, a permanent political entity with authority over a defined territory. The state remains the same even when the governing party changes, except in extreme cases like revolutions or changes in geographical boundaries. Executive at national level. The focus here is on the national executive. However, similar executive structures exist at the provincial and local levels. At the provincial level, these are headed by the Premier and the members of the Executive Council, MEX. Separation of powers and checks and balances. The separation of powers doctrine and checks and balances framework apply, particularly concerning the President's appointment and dismissal. The Executive's powers are intertwined with Parliament's ability to hold the Executive accountable and the Judiciary's role in constraining the Executive's exercise of power. 5.2 The President. 5.2.1 Election, term of office, and removal. The process by which the President is elected, their term duration, and the grounds and procedure for removal are defined by constitutional principles. 5.2.2 The President as head of state and head of the executive. The President serves dual roles, as head of state and as head of the executive. 5.2.3 Limits on the exercise of presidential power. Presidential power is not absolute and is subject to constitutional limits and mechanisms for accountability, including judicial review and checks from Parliament. 5.3 The Deputy President and the rest of the Cabinet. 5.3.1 Appointment and removal. The Deputy President and Cabinet members are appointed by the President and can be removed by the same authority, following constitutional and legal procedures. 5.3.2 Powers of the Deputy President and the Cabinet. The Deputy President and Cabinet members exercise executive powers in specific areas delegated to them by the President. Their powers are constrained by the broader constitutional framework and subject to parliamentary and judicial oversight.